ये आपको जो डिक्टेशन मिल जाएगी 114 के 114 के नाम से मिल जाएगी सॉफ्टवेयर के अंदर। इसमें दोनों होंगे @80 और @100। पहले 100 बोल रहा हूँ, फिर @80। जो @100 बोली जा रही है उसमें 1000 वर्ड प्लस वर्ड ले जाते हैं, मतलब कॉम्बिनेशन किया जाता है दो डिक्टेशन को मिला के, एक पूरी 840 की, साथ में 200 वर्ड एक्स्ट्रा एड ऑन कर दिए जाते हैं। ठीक है। इसके बाद में जो 80 है वो एज इट इज बोली जाती है, जिसमें 840 वर्ड है, क्योंकि एग्जाम के अंदर जो क्राइटेरिया होता है 800 वर्डों का होता है और वो 1000 वर्डों का होता है, तो हम 840 और 1040 के आसपास वर्ड रखते लेके चलते हैं। तो डिक्टेशन लिखेंगे पहले 100 पे, उसके बाद फिर 80 पे। इसके अलावा आप जो कर रहे हो रूटीन बेसिस पे अपना होमवर्क करते रहना। अगर आपको इस बार सिलेक्शन में लेना है, 2026 में सिलेक्शन लेना है, इस स्टेनो में अपनी एक्यूरेसी और स्पीड को ध्यान में रखते हुए जो भी चल रहा है उसको एज इट इज अपग्रेड करते हुए, ऐसा नहीं कि एक कर रहे हो बस एक ही करते यार, उसको अपग्रेड करते चले जाना और अपने रिटर्न पे फोकस रखना। रिटर्न का फोकस अभी से स्टार्ट कर देना, अप्रैल में आ जाएगी डेट, अगस्त के आसपास एग्जाम बैठेगा, तो इंग्लिश को रीजनिंग को बड़ा फोकस होकर चलो। जीएस जो आपका 6 मंथ का है अभी से जनवरी से स्टार्ट कर देना उठाना, जनवरी जो करंट के लिए, और बाकी बेस बुक जो आप लेके चल रहे हो, जो भी आपकी है लूसेंट है या जो भी आपकी बुक है XYZ, बेस बुक तो कोई ना कोई लेके चलता ही है, किरण वगैरह जो भी आपको अच्छा लग रही है उसको लेके चलो। बेस बुक को अच्छे से मगअप कर लेना अगर आपको जीएस में 18 से 22 स्कोर करना है। फिर करंट उसके ऊपर डिपेंड करेगा, अगर जीएस आप 30 के आसपास कर जाते हो, इंग्लिश 90 प्लस रखनी है, रीजनिंग 45 प्लस रखनी है, तो सेफ जोन चला जाता है। और अभी से तैयार करना पड़ेगा आपको सब चीज़ों को, मतलब थोड़े से वैसा मत करना कि लूज मत पढ़ना, एग्जाम को लेकर बहुत ज़्यादा फोकस रहना। ठीक है। और स्टेनो में जब टाइप करते हो जो गलती आती है उन पर काम हमेशा करना। अगर आपने टाइप करके गलती पर काम नहीं किया ना तो उसमें इंप्रूवमेंट नहीं होता, वो कोई लाभ नहीं होता उन चीज़ों का। रेडी। 100 पे लिखेंगे पहले, स्टार्ट इट। Mr. Deputy Chairman, Sir, in pursuance of the government's policy to secure the active cooperation and involvement of all democratic, secular and progressive forces in the country, it was considered desirable to have a dialogue with Sheikh Muhammad Abdullah. Honorable members are aware that Sheikh Abdullah had played a notable part in the freedom struggle and in the accession of the state of Jammu and Kashmir to the Indian Union. He formed and headed the government of the state for a number of years after independence, despite the differences which led to the subsequent estrangement. It seemed clear from the public statements made by Sheikh Abdullah as well as personal talks with him that his commitment to basic national ideals and objectives had remained unchanged. He reaffirmed that the accession of the state to the Indian Union was final and irrevocable. His main area of concern was about the legal and constitutional changes made after August 1953. It was decided that Mirza Afzal Beg, whom Sheikh Abdullah named for the purpose, and Sri G. Parthsarathi, whom I entrusted with the task, should examine these changes in depth and make appropriate recommendations. After extensive discussions, they reached agreement on various points which are incorporated in the agreed conclusions, a copy of which is placed on the table of the House. These conclusions form the subject matter of further discussions at a political level, in which Sheikh Abdullah and the Chief Minister of the state and Sardar Swaran Singh participated. As a result of these, an understanding has been reached as disclosed in the letters exchanged between me and Sheikh Abdullah, copies of which are placed on the table of the house. I shall refer to certain basic features of the understanding. The agreed conclusions have been formulated within the framework of the Constitution of India. The constitutional relationship between the state of Jammu and Kashmir and the Union will continue as it has been, and the extension of further provisions of the Constitution to the state will continue to be governed by the procedure prescribed in Article 370. There will be no weakening of the ties which exist between the Union of India and its constituent units, of which the state of Jammu and Kashmir is one. The existing jurisdiction of the center to deal with activities directed towards questioning or disrupting the sovereignty and territorial integrity of India, or bringing about cession of any part of the territory of India from the Union, will also continue. It has also been agreed that any amendment of the Constitution of the state on certain specified matters of importance will not become effective unless the assent of the President is obtained. The agreed conclusions seek to reassure the state that in case the state government comes up with any proposal to change any central law made after 2003 on matters in the concurrent list, such as social welfare measures, cultural matters, social security, procedural laws, and the like, the grant of assent to the bill will be sympathetically considered. A proposal was made by Mirza Afzal Beg that the jurisdiction of the Supreme Court in relation to the state should be curtailed. This was not accepted, as it is considered important that the Supreme Court should continue to have its original and appellant jurisdiction in the matter of writs, appeals, and other matters. However, it was agreed by collateral letters that the provision in Article 132 enabling the Supreme Court to grant special leave on the refusal of a certificate by the High Court need not apply to the state. Action on this will, however, be taken only when the state government comes up with a proposal in this behalf. Honorable members will notice that the question of nomenclature of the governor and the chief minister could not be settled. This is a matter which is provided for in the state constitution, which at present uses the expression governor and chief minister. A change in the nomenclature can be made only by amendment of the state constitution by the state legislature. So far as the chief minister is concerned, there should be no objection to the adoption of the designation prime minister in the state if the legislature of the state of Jammu and Kashmir amends its constitution accordingly. Until this is done, the present designation would continue. Sheikh Abdullah was very anxious that to start with, the constitutional relationship between the state and the center should be as it was in 2003 when he was in power. It was explained to him that the clock could not be put back in this manner. Mirza Afzal Beg pressed for the transfer of provisions relating to fundamental rights to the state constitution, the removal of the supervision and control of the Election Commission of India over elections to the state legislature and the jurisdiction of the Supreme Court over all subjects in the state list. Madam, I beg to move that the bill further to amend the Northeastern Areas Reorganization Act 2001 be taken into consideration. Madam, this is a simple piece of legislation which seeks to replace the Northeastern Areas Reorganization Amendment Ordinance 1975, which was promulgated by the President under Article 240 of the Constitution on the 20th January 1975. As a result of reorganization of the composite state of Assam under the Principal Act of 1971, as from the 21st January 1972, the Assam State Electricity Board and the Assam State Warehousing Corporation existing at the time in the composite state became interstate bodies corporate. A provision was made in section 53 of the Northeastern Areas Reorganization Act 1971 for the continued functioning of these two bodies in all the territories of the composite state, that is, the present state of Assam, the state of Meghalaya, and the Union Territory of Mizoram. It was also provided in subsection 3 of the same section that these bodies shall cease to function and stand dissolved on the expiry of the period of 2 years from the date of reorganization or such earlier date as the central government may by order decide. ये 1000 वर्ड प्लस वर्ड डिक्टेट किए गए हैं, आपको SSC C&D ग्रेड टेस्ट नंबर 114@80 के नाम से मिल जाएगा, सॉरी @100 के नाम से। स्पीड 100 की है, फ्लेक्सेशन ना के बराबर है, 80 पे लिखेंगे। रेडी, स्टार्टेड। Madam, there is a strong feeling among the members and they pay a tribute to the Joint Select Committee, whose report is very instructive and contains dissenting opinions which I consider very valuable. But I have to make some observations because this bill raises vital issues of constitutional importance. This bill has created doubts in the public mind about the advisability of some of its provisions, and I feel that I owe it to the rule of law and to the profession to which I belong and which I have served for more than 45 years, and to this Parliament, that I should freely and frankly express my views and the doubts raised in the public mind so that the government may be in a position to remove those doubts. Madam, there is first the question of the determination of the age of Supreme Court judges. So far, no Supreme Court judge has raised any dispute about his age, and I have got a genuine belief that there shall never be a dispute which, with regard to the age of any Supreme Court judge, I feel that when future appointments are made, the government will take ample care to have sufficient proof of age. If they care, they can put down the age in the warrant of appointment, or they can have a declaration or even an agreement. The question then is, why put an unnecessary provision in this constitutional amendment? We know that our constitution has been the subject of study throughout the world. Among the jurists and international organizations, and they will get the impression that after so many years of independence, some questions have been raised about the age of the judges, which required constitutional amendment. That will cast a reflection upon the dignity of the judiciary if we find that there is only just a stray case or two in which the question of the age of the judge is involved. Will it then be necessary to amend the constitution? When there is no case about a Supreme Court judge and no circumstance has arisen which calls for an amendment of the constitution, we must not do anything against public feeling which may even remotely cast a reflection upon the dignity of our judges. The provision regarding the determination of the age of High Court judges is important, and I believe that it deserves very careful consideration. The provision in this bill is that the President shall decide in consultation with the Chief Justice. The judge in the dispute between the executive and a judge will be the head of the state, will be the head of the executive, and the Chief Justice comes in as a consultation tent. Now, this question of age is what we call a justiciable question. It is like the question of misbehavior or the question of incapacity of a judge. In other words, this is a question which will depend upon the determination of a dispute on an appraisement of evidence produced before the person deciding. Therefore, it is like a question of misbehavior or incapacity of a judge. Now, since the year 1700 in England, there have been three principles recognized which have not been departed from in any civilized country, and in particular in any democracy and which assure the independence of the judiciary, and it is acknowledged on all hands that the independence of the judiciary is an essential condition of democracy. Now, this has been incorporated in our Constitution in Article 124, and if we bear in mind the constitutional history of the appointment of judges, we will find that in cases where Parliament is functioning, it is only after a judicial determination by Parliament on this question of misbehavior or incapacity in the presence of the judge that a formal order would be passed by the head of the state. Nowhere has the head of a state acted as a judge in person. The Constitution has entrusted the question of the decision of disputes between a private party and the state to the judiciary, and the question then arises whether this bill has departed from this principle. If this bill has departed from this principle, then an inconsistency has been introduced, and while in Article 124, the question of a justiciable issue or a dispute has been assigned to Parliament, the question of age, which stands on the same footing as a question of incapacity because it is a dispute with regard to the tenure, has been assigned to the executive. Now, this is a matter which deserves serious consideration. This is what the public outside say. Since 1700, any dispute regarding the tenure of a judge has never been decided by the executive. Shall we be the first to depart from that principle? When we had no Parliament in this country, it was the judges who decide a question between a judge and the state. When Parliament came into existence, we adopted the principle of the British Constitution. 840 वर्ड डिक्टेट किए गए, 80 की स्पीड है, फ्लेक्सेशन ना के बराबर है, और ये आपको SSC C D डिग्रेड टेस्ट नंबर 114@80 मिल जाएगा। अगर आपको इसको 9 कॉमा वाली फाइल पे टाइप करना है तो इसका नंबर 445 है, केसी सोर्स है।